Good evening. This webinar offers closed captioning. To enable closed captioning, you can click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note that any website or email that I mentioned will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall or call 312-744-6249. Also, business licenses can be applied for or renewed online at chicago.gov/business licensing. The BACP Entrepreneur Certificate Program now has a new portal, and getting your certificate is as easy as 1, 2, 3. You can register for the BACP Entrepreneur Certificate Program. You can attend 6 free BACP webinars from listed categories and receive credit after each webinar. And then you graduate from the program and receive your certificate. Graduating from the BACP Entrepreneur Certificate Program makes you eligible to apply for CIBC Bank USA's Entrepreneur Loan Program. For full program details, please visit chicago.gov/BACP certificate. For webinar calendar, please visit chicago.gov/BACP webinars. If you are already part of the program, your account will automatically reflect the credit for joining tonight's webinar. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. As mentioned before, I will post all of the mentioned information in the chat box. We encourage attendees to ask questions. You may use the chat box to send your questions or the Q&A functionality to send your questions. We will have a question and answer session at the end of tonight's presentation. Tonight's webinar will be an overview of Chicago's paid leave and paid sick and safe leave ordinance, and an overview of the Cook County Paid Leave Ordinance. Your presenters this evening will be Miguel Campos, the Director of the Office of Labor Standards, and Jennifer Keene, the Director of the Cook County Department of Human Rights and Ethics. So I'll properly introduce myself. I am Miguel Campos. I'm the Director for the Office of Labor Standards, which is contained within the Department of Business Affairs and Consumer Protection. This is the outline of tonight's webinar. So I'll present first. We'll quickly cover the mission of the Office of Labor Standards. Then we'll dive into details on the paid leave and paid sick and safe leave ordinance, including history and implementation. We'll cover material, which will include who's covered, what is paid leave versus paid sick leave, how one would go about accruing and using paid leave and paid sick leave, any notice and documentation that's required by the ordinance, the Office of Labor Standards required posting. We'll cover employer policies, private right of action. We'll briefly go over the rule and outreach efforts that are being taken by the Department of Business Affairs and Consumer Protection. We will cover investigations and enforcement, and then there'll be a couple of slides on the OLS website and the YouTube page, which I've mentioned a couple of times this evening already. After I present, as stated, the Cook County Commission on Human Rights Director Jennifer Keene will speak on Cook County's paid leave ordinance. So their mission, the actual ordinance, applicability of the ordinance, employee rights, employer responsibilities, their complaint process, enforcement and penalties, and then a small section on jurisdictional similarities and differences between the county and the city. As stated, we will ensure that we leave plenty of time at the end of today's presentation to answer as many questions as we can. And again, you can ask questions by typing them into the chat box or the Q&A functionality of this Zoom webinar. So this is an overview or mission of what the Office of Labor Standards does. So the office is dedicated to promoting and enforcing Chicago's labor laws. We seek to engage communities and protect workers through a strong investigation and enforcement regime. We process complaints, we conduct investigations, we mediate disputes, we direct settlement proceedings, we issue violations, and if necessary, we can seek licensure discipline against employers. On the right-hand side of your screen, there are general overarching data facts for last year. This data is for January through December of 2023. The office received over 600 complaints. We closed over 400 of them, and we were able to recoup over $430,000 in restitution that went directly back into the pocket of workers. So we are here this evening to talk about Chicago's paid leave and paid sick and safe leave ordinance. So on November 9th of last year, the Chicago City Council passed the Chicago paid leave and paid sick and safe leave ordinance. On December 7th, the city's Workforce Development Committee passed an amendment to the ordinance, which was voted on by full City Council on December 13th. With the December 13th vote, the implementation of the ordinance in the city was delayed until July 1st of 2024. So we're roughly 2.5 months away from that implementation date. So the first thing we're going to cover this evening is who is covered under these ordinance. So to start off with, the ordinance guarantees up to 5 days of paid time off and 5 days of paid sick leave for all of Chicago's workers. In order to be a covered employee under this ordinance, that means that you are an employee who works at least 80 hours for an employer within any 120-day period while you are physically present within the geographical boundaries of the city. An employee is an individual that performs work for an employer in the capacity of an employee as distinguished from an independent contractor. And this is determined pursuant to the Internal Revenue Service guidelines. And then an employer, for our purposes, for the purposes of the city, is any individual or person who gainfully employs at least one employee in the capacity of employee and not an independent contractor. I would like to point out that if you are hiring a domestic worker, regardless of whether that individual is a 1099 employee or not, and domestic worker would be considered a covered employee. That is one obvious exemption that I wanted to point out. So I keep mentioning paid leave and paid sick leave. So what do these terms mean? So paid leave means time that is provided by an employer and can be used for any reason of the employee's choosing, and it is not paid sick leave. Paid sick leave is time that's provided by an employer and can be used to recover from an illness, for an employee to take care of a family member and address domestic violence situations or any public health emergencies. How does one go about accruing and using this paid leave and sick leave? So paid leave in the city, an employee earns 1 hour of paid leave for every 35 hours worked. There's a maximum of 40 hours or 5 days in a 12-month period or a benefit year. Again, paid leave can be used for any reason, but the request to use can be denied by an employer, and we'll dive into those details in a little bit. Paid leave, an employee can request to use their paid leave 90 days after July 1st, which is when the ordinance goes into effect, or after their start of employment, whichever date is later. We do have a minimum usage increment that cannot exceed 4 hours. So this is the highest minimum that an employer would be able to request that an employee uses their paid leave in. Sick leave is earned at the same rate. So it's 1 hour of paid sick leave for every 35 hours worked. Again, up to 40 hours or 5 days in a 12-month period. These are minimums. An employer can choose to provide more, but at minimum, they must provide up to 5 days in a 12-month period or a benefit year. Sick leave can be used to recover from an illness, take care of a family member, address domestic violence issues and public health emergencies. An employee has quicker or faster access to their sick leave. So sick leave can be used 30 days after July 1st of 2024 or after their start of employment, whichever is later. The city has a current paid sick leave ordinance where people are earning paid sick leave already. This would transfer over. And then the minimum usage increment for sick leave is not to exceed 2 hours. So that is the highest minimum that an employer can request an employee uses. And I have examples here for both paid leave and paid sick leave. So the first example is for paid leave. So Miguel or me, I want to take 2 hours of leave to attend a Cubs game. Again, there is a minimum increment, usage increment that an employer can set. So my employer can have a policy that requires that I use 4 hours of it. So I will not be able to use it in 2-hour increments. And then the example I have for paid sick leave is I want to take 2 hours of leave to take my daughter to a dentist appointment. So this would be allowed, and an employer may not instead require me to use 4 hours or 8 hours instead. So I'm able to use it in that 2-hour increment or 2-hour window. There are carryover and payout components to the paid leave and paid sick leave ordinance in the city of Chicago. So for carryover, you are allowed to carry over up to 16 hours or 2 days of any paid leave that you accrued and then not use. If your employer front loads, so if you get all of your paid leave up front rather than earning it as you work, then they have the option of not allowing carryover. And then for paid sick leave, an employee can carry over up to 80 hours of 10 days of paid sick leave. And then this is whether the time is front loaded or it is accrued. So for payout, I want to reiterate this important fact. Payout at the end of an employment relationship is not required for paid sick leave. However, it is required for paid leave. So it's required for any large employer, which we're defining as someone who employs 101 or more employees, covered employees. So if you're a large employer, you are to pay out any unused paid leave that an employee has accrued. For a medium employer, which is 51 employees to 100, there's a ramp up provision. So the first year, you would have to pay out 2 days or 16 hours or up to, again, if someone has it and it's available for use. And then after July 1st of 2025, you would be required to pay out all earned, accrued, paid leave that went unused. And then it is not required for a small employer, which would be anyone that has between 1 and 50 covered employees. There are notice and documentation requirements built into the ordinance. So for paid leave, as stated a few minutes ago, an employer has an option or an ability to establish a pre-approval policy to ensure continuity of their business operations. I do want to point out that any usage of paid leave cannot require documentation. Again, you cannot ask an employee why they're using their paid leave. It's their leave to use as they see fit. And again, for paid leave, I want to remind everyone of that minimum usage increment, which is not to exceed 4 hours. For sick leave, an employer can require up to 7 days notice if the usage is foreseeable or as soon as an employee becomes aware of the need for leave. So an example of when usage is foreseeable is if you have an upcoming dentist appointment or a doctor appointment. You're going in for your annual physical, you're going into the optometrist to update your eyeglass prescription, you would be able to, that usage would be foreseeable. So I can tell my employer, I have a doctor's appointment this coming Monday, I wish to use my sick leave. Unlike paid leave, there are instances when documentation can be required. So you can ask an employee to provide documentation for their sick leave only after that employee uses paid sick leave for 3 consecutive workdays. And then the minimum usage increment for sick leave, as a reminder, is not to exceed 2 hours. Employers are required to post informational posters at their places of business. And then in addition, a copy of it has to be provided to employees on an annual basis. So these are proposed notices. So at the moment, we have a single page notice. Starting July 1st, we are transitioning to a 2-page notice, and they're similar. So the first page contains information on the city's minimum wage, information on wage theft, information on reporting human trafficking and accessing resources for human trafficking. And then there are a couple of boxes that detail information on how someone can go about filing a complaint with the Office of Labor Standards. And then a guide to additional resources and contact information. So our address, our email and phone number, a link to our YouTube page where there are webinars that are being recorded, and then how someone can go to our website to obtain additional resources. The second page is going to contain information on paid leave, on paid sick and safe leave, employee policies, so how one earns time, uses time, carryover, so everything that we've covered in tonight's webinar. And again, it ends with information on how someone can go about filing a complaint, and then additional resources and contact information for the office. This proposed posting will be available on the OLS website. We will make it available in simplified Chinese, English, Korean, Polish, Spanish, and Tagalog. These are the 6 most commonly spoken languages in the city of Chicago. An employee can request additional language from our office if needed. So if someone wants something in Russian or Ukrainian or any other language, you can reach out to us, and we will make sure that these required postings are made available in the requested language. I mentioned employer policies. So there has to be a written notification of available leave. So every time an employee gets paid, they'll get a notification of how much time they've earned since they last got a notification, if they've used any leave, and any available leave to be used. This written notification can be provided via reasonable systems. It could be part of a pay stub. It could be a separate written notice. It could be part of an online system where employees can access their own information. So in essence, it's just letting me know it's April 16th. You have earned 8 hours of paid leave this year. You've used 4 hours. You have 4 hours left to use. So it's in essence an accrual report. The paid time off policy. So it is required for an employer to have a paid time off policy, and that you provide your policy to the employee. It's to be given at the commencement of employment and within 5 days before any changes are made to an existing policy. So your policy, and then we're going to provide checklists so that employers are able to look at their policy and see if it meets all the requirements of the ordinance. So your policy should include information on how time is accrued, what period it's accrued on, is the time front loaded, what's the definition of your benefit year? Is it anniversary from date of hire? Is it your standard January 1st to December 31st calendar year? Do you have a tax year? Do you have a fiscal year that you're changing on your own? So for example, it could be June 1st to May 31st. The city is not dictating what your benefit year is. An employer is able to choose whatever benefit year they want to use, as long as it's consecutive 12 months period. We're not requesting that, for example, everyone transition to July 1st to June 30th date. You can keep your existing benefit year and do whatever best practice is best for your business. The paid time off policy should also include any notification requirements if they exist. So how would I go about asking for time off? Do I email my supervisor? Do I send them a text? Can I make a phone call? Is there some sort of online scheduling app that I'm supposed to like put my request in for? And then if you have any pre-approval methods for the paid leave. So if your employer is going to dictate that only a certain percentage of employees are able to take Christmas Eve off, that should be part of the paid time off policy. And then an employer can choose whatever policy they want. I'm going to allow for 50% of my staff to be off on Christmas Eve. It'll be based on seniority, or there's a blackout date. So no one's allowed to take time off the last week of November of every year. As long as it's written and it's provided to an employee ahead of time, you would be able to set such policies. And I do want to point out that the paid time off policy is to be provided in the primary language of that covered employee. Private right of action. So for the paid leave component of the ordinance, an employee does not have an ability to file a lawsuit on their own that is delayed until July 1st of 2025. So starting July 1st of 2025, then the city will have a 16-day cure period, which must occur first before a private right of action can be taken. So it's the next pay period or 16 days, whichever amount of time is less. This cure provision is going to sunset on its own accord unless the city council takes further action. And then that July 1st, 2025 period to June 30th, 2026, our office will provide a report that's going to inform any future city council action. So this is only for the paid leave component. For the sick leave component, private right of action is immediately available. It's available at the moment under the current paid sick leave ordinance, and it'll be immediately available come July 1st of 2024. I mentioned that the department is engaged in outreach activities. So I would like to start off with a reminder that record requirements under the ordinance that must be kept by employers only apply to covered employees whose regular work duties occur within the geographical boundaries of the city. So the city published proposed rules on December 20th of 2023. We had a public comment period, which ended February 16th of 2024. We finalized reviewing each individual public comment. If necessary, we've incorporated them into a new updated version of the rules. So those rules are in the process of being finalized and should be in place no later than May 15th of 2024. Outreach presentations. There is an FAQ document on the city BACP Office of Labor Standards website. It's available in both English and Spanish. OLS has held webinars which were recorded, just like tonight's webinar is being recorded, on December 14th in English and December 15th in Spanish. We had another joint webinar with the Cook County on January 22nd, which can also be accessed via the department's YouTube page. And then we are going to host and record subject-specific webinars in May and June. There'll be a minimum of 6. The webinars are going to be tailored to specific subsets of relevant stakeholders. So whether it's an advocate group, an auxiliary industry such as a HR professional, an attorney, a tax professional, and then of course, employers and workers. And again, I want to remind everyone, and I'm going to type in all of the websites I've mentioned in a little bit in the chat, that these will be available at the BACP YouTube page, just like today's webinar will be available as well. And then in addition to that, the city will publish and issue specific fact sheets. So there'll be a fact sheet on accrual, there'll be a fact sheet on usage of time, there'll be a fact sheet on front loading time, on carryover, on payout, with concrete multiple examples. And then we're also going to provide templates for policies for employers. And then those should be up on our website within the next month. This is our complaint and investigation process. So if you're an employee and you feel that any of your labor rights or protections have been violated, you can file a complaint online or by mail. You can call 311. You can use the city's Shy 311 app. You can also download the complaint form off of our website. You can send it in through US mail if you prefer. You can fax it to us. We accept complaints in numerous methods. After we receive a complaint form, we'll review it. We'll contact the complainant, conduct an intake or triage interview, ensure that it's something that is under the city's jurisdiction, and then we'll commence an investigation. We have the ability to issue subpoenas, to review records from an employer. We will then enter into settlement negotiations if violations are found. And then if settlements negotiations prove to be not fruitful, then we have an ability of filing a case with the mayor's licensing division at the Department of Administrative Hearings or circuit court if necessary. I keep mentioning our website. So the OLS website is a valuable research tool for both employees and employers. Each ordinance under our jurisdiction has its own section, and each subsection contains info on the ordinance. So applicable rules that pertain to that ordinance, FAQ documents. Again, that information is available in the top 5 languages spoken in the city. That website is chicago.gov/labor standards. And at the very top, there's an alert box that contains all of the pertinent information that we've discussed this evening. So there's the original November 9th ordinance. It's a hyperlink that takes you directly to a PDF document. There's a December 13th amendment. There's the FAQ document. There's informational flyers. The proposed rules are up there. The proposed posters that we discovered or discussed this evening are also on there. I'll end with the, again, the YouTube page, the youtube.com/ChicagoBACP. In addition to tonight's webinar, there are recordings of 45 other webinars that the Office of Labor Standards has hosted throughout the year. And again, I'll type this in the chat box shortly. Finally, here's our contact information. I will re-put this back up after Director Keene finishes her presentation in case people want to reach out with further questions. Our main phone line, someone will answer Monday through Friday, 8:30 to 4:30. You can leave a voicemail over the weekend and we'll return a call on the next available business day. You can email bacplaborstandards@cityofchicago.org or bacpoutreach@cityofchicago.org, and then our mailing address is at the bottom. So I will stop sharing my screen and I will transfer things over to Jennifer Keene.
Thank you so much. And I'll share my screen once you.
Yeah, I'll stop sharing now. You should be able to share your screen.
Thank you. Great. Good evening, everyone. Jennifer King, Director for Cook County's Department of Human Rights and Ethics, which includes Cook County's Commission on Human Rights. The commission is responsible for enforcing the county's human rights ordinance, as well as a number of labor protections, including the newly enacted paid leave ordinance. The ordinance is currently in effect. It is effective as of December 31st of 2023, and the commission began enforcement on February 1st of this year. Our Cook County Board of Commissioners approved the paid leave procedural rules, and they became effective on March 14th of 2024. I'll note that Cook County's paid leave ordinance establishes the minimum paid leave required for employees working in Cook County. It requires that employers give workers or employees at least 1 hour of paid leave for every 40 hours worked, and that those employees can use that paid leave for any reason. And, where does it apply? You've heard a lot about Chicago's ordinance, and you're probably trying to figure out when one ordinance applies over the other. So Cook County's ordinance applies to employers with employees who work within the geographic boundaries of Cook County. It does not apply to municipalities like Chicago, who already have an equivalent ordinance in effect. I'll note too that park districts and school districts are currently exempted from Cook County's paid leave ordinance until January 1st of 2025. So which employees are covered? So full-time, part-time, temporary, seasonal, domestic workers, they are all covered under the paid leave ordinance. I'll note that an individual must work or perform at least 50% of their compensated work within Cook County or within the boundaries of Cook County where the paid leave ordinance applies in order to receive the paid leave benefits required under the ordinance. So what this looks like is there is an employee who maybe does deliveries and they have an 8-hour workday. If they are working at least 4 hours, spending 4 hours of their workday in Cook County, then they're subject to receive paid leave benefits under the ordinance for the hours worked in Cook County. So for that 4 hours that day and 6 hours another or something like that. So only for the hours worked within the physical boundaries of Cook County would that apply. It does not apply to a number of employees. I'm going to flag two here. The first is independent contractors. The exception there, similar to Chicago, is for domestic workers who are independent contractors. They are included regardless of their designation, but any other independent contractor would not receive benefits or paid leave under this ordinance. And also any employee who is covered under a collective bargaining agreement that was in effect at the time in which the ordinance went into effect. So essentially on or before December 31st of 2023. If there are any employees who are entering into an agreement after that effective date, there has to be an express waiver of the rights under the paid leave ordinance that is written in the agreement. So joint employers, flagging this here. If there are two or more employers who have control over the work of an employee, an example would be there's an individual who works as a nanny for 2 households. Those 2 households or employers are subject to the ordinance and are responsible for complying with all of the requirements of the paid leave ordinance. They're both required to maintain records associated with that employee, and ensure that they're receiving their benefits, the paid leave benefits under the ordinance. I'll note that those joint employers may agree to allocate responsibility amongst themselves. So employer A and B may agree that employer A will be responsible for maintaining all of the records, recording used and unused paid leave and such. An exception to flag is that staffing agencies are always going to be considered the employer. There's no agreeing to allocate responsibility to the workplace assignment. The staffing agency is required always to fulfill all of the employer responsibilities under the paid leave ordinance. Okay, so what is the role of the employer and responsibilities? The first requirement is that employers must notify their employees of their rights under the paid leave ordinance. This includes providing notice by posting the required workplace poster in a visible location, in a visible place at all physical locations or work sites. That notice should be provided or posted also in the language that is commonly spoken by the majority of their workplace. And also, if an employer has employees that are not assigned to a physical workplace, they're required to distribute notice of the ordinance and via the means that they normally use to communicate. So that could include email if you have a worker portal or a company intranet and such. In addition to that, employers are also required to provide a copy of the paid leave ordinance. And this is an example of the workplace poster or notice that should be posted or otherwise distributed to employees who are covered under the ordinance. This is available on our website in English and in 6 additional languages: Urdu, Filipino, Polish, Spanish, Arabic, and I believe Chinese. Additionally, employers should provide a copy of their written paid leave policy. This is very similar to what was previously mentioned as required under Chicago's ordinance. And so this should include what calculation method you're choosing, which we'll get into in a little bit, which employees those calculation methods apply to, the rate of accrual. I'll note that while the ordinance requires a minimum of 1 hour for 40 hours worked, an employer may choose to provide more than that. And so that should be very clearly communicated. The policy, if it's that you're giving 2 hours for every 40 hours worked, that should be included in your paid leave policy. And any terms and conditions on an employee's use of paid leave. So that may be particular preferred methods for making requests, whether that's an email, whether that's through some sort of portal. Also, if there are any time frames in which they must provide request when the leave is foreseeable. In our procedural rules outline exactly what is foreseeable leave versus unforeseeable. And so in those cases, all of that should be in a written policy that is distributed to your employees. Any changes to your policy must be shared with workers in writing as soon as practicable and no longer than 5 days after the change or within the time that the change was made. So I kind of alluded to this a bit earlier, methods for calculating paid leave. So there are 2 methods for calculating paid leave for employees under the ordinance. The first is accrual, so that 1 hour for every 40 hours worked, which you can also break up for, based on accrual for 1 hour or 5 hours worked, so long as it's all totaling up to what would equal 1 hour for every 40 hours worked. And then the second method is front loading. So you can provide employees with a set amount of hours that they can use for leave at the beginning of their employment or at the beginning of their accrual period. And so this looks like an employee is expected to accrue 40 hours within a particular accrual period or a year. And so you front load that 40 hours for that employee for their use. I'll note that if that employee, it turns out that they did not work the hours, if they were accruing using the accrual method, they would not have accrued 40 hours. You cannot go back as an employer and reduce the number of hours that were provided or otherwise require them to pay those hours back. However, in the inverse, if the estimated hours that you decide to front load is less than what they would have accrued, then you should provide those additional hours. So using that same example, an employee actually worked and would have accrued 40 hours within a year, but 35 hours were front loaded for their use. That extra 5 hours should be provided to them. It's like making them whole, essentially. I'll note too, we recognize that employers have different groups of employees where for some it may be easier to determine or estimate how many hours they would accrue in 1 year. And then others where their schedules are maybe more varied and the accrual method is more appropriate. So you can provide different calculation methods to different groups of employees. However, that should be clearly written in your policy as to which employees or classification of employees are receiving this accrual method versus the other. Also, of course, in all the work that we do, ensuring that the policy is not discriminatory, that it's not determined that this group will receive this accrual method or that accrual method based on a discriminatory basis. And of course, otherwise, you're required to comply with all other provisions of the paid leave ordinance. Rate of pay. So when employees use their time off, they should be receiving compensation for that time off at their regular rate of pay. So this may include whatever salary or hourly wage that you're paying that employee. For any employees who are ordinarily receive tips, you're not required to provide any gratuities that they would have otherwise received if they worked that day. And also, if they would have worked overtime, you're not required to give them the extra amount of pay or include that as you're paying them for the paid leave that they're using. I'll note that if an employee is a tipped worker who's receiving the minimum wage for tipped workers, when they use paid leave, the rate of pay should be the non-tipped minimum wage. And any workers who receive commission or commission-based employees should receive, their rate of pay should either be their base wage or the applicable minimum wage for non-tipped workers, whichever is the greatest. So use of paid leave, as I noted earlier, it can be used for any reason, whether it's if you're providing that minimum 40 hours, it can be used for travel, attending to a family member, they have a doctor's appointment, for whatever purpose that they determine that they want to use their paid leave for. The leave will be allowed, an employee can start using their leave 90 days after their start date. For employees who were employed before the passage of the ordinance or at the time the ordinance was passed, on March 1st, they were able to start using any leave that they accrued or that was front-loaded. I'll note too that employers can allow their employees to begin using paid leave earlier if they choose. And this is just a reminder that paid leave ordinance is setting the minimum requirements. So it's the floor of what everyone should be receiving, but employers, of course, can choose to provide more to their employees if they choose. So increments of use, employers cannot require their employees to use paid leave in increments that exceed 2 hours at a time. And so when an employee is making a request, it would be a violation of the ordinance to require that they use a minimum of 4 hours of paid leave at one particular time. However, you could allow an employee to take leave 1 hour at a time or 30 minutes if that's what you decide to be your policy. And carryover. So if an employee is receiving paid leave via the accrual method, so that 1 hour for every 40 hours worked or 0.5 hours for every 20 hours worked, however that's broken down, any paid leave that is unused at the end of a 12-month period, or what we refer to as the accrual period, is required to be paid over. Now, employers can place a limit on how many hours can be carried over from 1 year to the next, but it cannot be less than 40 hours. So if an employee accrued 50 hours within a particular year or accrual period, and they didn't use any of that time, they're allowed to carry over 40 hours of that unused time to the next benefit period or accrual period, and then continue accruing leave at the rate at which has been set by their employer. Any employee who has received front-loaded paid leave, it's not required that they carry over any unused leave. An employer, of course, can allow that, but the ordinance does not require that front-loaded leave that is unused be carried over from one accrual period to the next. Great. So payout and reinstatement. So similar concept. So if an employee separates from employment for a number of reasons, termination, resignation, retirement, or any other separation, any unused paid leave at that point is only required to be paid off if it is credited to a worker's paid time off bank or vacation bank. There's no requirement under the ordinance that the minimum amount of leave or the leave that's required under this ordinance be credited to a paid time off bank or vacation bank that's required to be paid out upon separation. I'll note that if time is credited to a paid time off bank or vacation bank, that unused paid leave should be paid to the employee within the next pay period. So that's where the 15 days comes in. If an employee separates from the employer at the end of one pay period, by the next pay period, they should receive payout for any unused leave. If an employer rehires an employee within 12 months of their date of separation, and that leave, whatever unused leave they had, if that was not paid out, it should be reinstated immediately. So any paid leave that was previously paid out to a rehire is not required to be reinstated because they've already received some sort of compensation for that leave. Okay. So there are occasions where paid leave requests may be denied. And so here are some considerations around when an employer is determining to deny a request for operational needs. And this may include whether that employer provides a need or a critical service to Cook County's health, safety, or welfare, considering how all requests are reviewed and if they're being treated the same. And then whether approving paid leave during the requested period would significantly impact business operations due to the employer's size. Previous example was given similar about operations, needing a minimum number of coverage, blackout periods, that sort of thing. All of those considerations, if an employer is deciding during these time periods, we won't approve leave request, or if only this amount of people can be out on this day, we need this minimum number of people to operate our business. All of that should be clearly written in a written policy. And so along with another responsibility, record keeping. So employers must maintain records for a period of 3 years. And this includes, of course, the employee's name, contact information, their start date, their classification. And along with that classification, if you're choosing to mix accrual methods, meaning this classification of employees receives front loading and this receives the accrual method, that should be included in the records, what accrual or calculation method is being applied to that employee based on their job classification. Classification also in position title, perhaps, the number of hours worked, the paid leave hours earned and used, remaining paid leave balances, and then if you're requiring, those written requests, keeping a copy of those in the record in their file is required under the ordinance. And I'll note too that if there's ever a time in which we receive a complaint at the commission, these are the sorts of records that we would request as we're reviewing the matter to determine if a violation occurred. Okay. So one resource that we've developed is a checklist for employers. It goes over some of the information that I just noted. So like establishing a paid leave calculation method for employees, drafting your written policy, providing a description of your paid leave benefits and associated practices to employees in writing. So this is currently available on our website for use and download, and we'll have a link to it to share also. So potential violations of the paid leave ordinance and what that looks like. Requiring a worker to find coverage as a condition of using paid leave. If employee A submits a request to take leave on a Thursday for 5 hours, and that employer cannot then say, yes, you can take leave, but you have to find someone to work those 5 hours, that will result in a violation. Similarly, paying a worker not to take paid leave, switching their work schedule after they provided notice that they're taking paid leave, or similar things will result in a violation. Also, not paying that employee at the appropriate rate when they're taking paid leave would qualify as a violation. Under our rules, employers have an opportunity to correct violations under the pay leave ordinance without penalty within 2 years of the ordinance effective date. So the Cook County Paid Leave Ordinance went into effect on December 31st of 2023. So from that point until December 31st of 2025, if an employer takes corrective action and basically makes that employee whole and comes into compliance with the ordinance, that will not result in the imposition of penalties against that employer. I'll note that full compliance can include payment of any lost wages to the affected employee. Now, if there is a violation found of a paid leave ordinance, an employer can be liable for damages, fines. A particular fine is applicable for notice violations. So that's failure to, example, provide that poster or post that poster in a conspicuous place at a physical work location. $500 for the first violation and $1,000 for every subsequent violation. And then we have a number of resources. Some I noticed with the workplace poster, the employer checklist. We'll be adding more that will be available on our website. But these are a few quick links. It includes our paid leave ordinance, the procedural rules, that notice, and FAQs, where we go into a little bit more detail and giving examples of how this applies. And our contact. Please feel free to contact us with any questions. I know we'll have the question session after this also. And I want to note that we will be hosting next week 2 additional trainings on paid leave. On April 23rd at 12 p.m., we'll be hosting a paid leave training for employers also. And on April 24th at 6 p.m., we'll be hosting a training for workers. We'll include, I think after this training, you'll receive a copy of the slides and the registration links for those 2 upcoming trainings. Thank you. Miguel, I'll turn it back to you.
Okay, thank you. I will leave the contact information for the county up on the page. We will use the remainder of this time to go through the Q&A. So we will attempt to answer as many questions as we can this evening. Again, if there are any questions that we do not get to today, feel free to send them to either the Office of Labor Standards or the county, and we will get you a response in writing. We communicate with each other routinely, so even if you send something to the Office of Labor Standards that would be better suited to be answered by the county, we can forward that message onto them. So let me look at our Q and A. So to Greg Simon, I will provide a detailed response to your question. It's a specific scenario that's rather lengthy. So I will provide an email response to you. So I should have your email from your registration. So I don't want you to think that I'm not answering it this evening. So we have an anonymous question. It is unclear from the ordinance and the proposed rules whether employers can prorate front-loaded leave for new hires and part-time employees. So I'll answer on behalf of the city. You are able to prorate front-loaded time. So let's say that you anticipate someone to work 20 hours a week, you would be able to front load half of that time. You should still keep track of the hours worked. So obviously there might be an occasion where that employee ends up working more than what you originally anticipated or front loaded, in which case you'll have to continue making them whole to whatever amount of time that they did work. And I'll let Ms. Keen answer on behalf of the county.
Thank you. Our answer is actually the same as that you would, and I'll give another example. Maybe I know that you noted if someone is a new hire. So maybe your accrual period is January 1 to December 31, and you hire someone in June. That amount that's front loaded should be based on how many hours you expect for them to work and what you expect that they would accrue as they work from June to December for that particular year.
The next question is, will employees be required to reinstate unused paid sick leave or paid leave if an employee is rehired within a certain period, such as 12 months? And I believe Ms. Keen answered that question during her presentation, but I wonder if she wants to elaborate.
Sure, I'll note, thank you. I'll note that, yes, if an employee is rehired within 12 months and they did not receive a payout for any unused leave when they separated from the employer, that unused paid leave should be reinstated for them.
There's 2 sick leave questions, which will be towards the city. So is it use it or lose it, or are employees required to allow rollover of unused sick leave? So the city is the only agency out of the 2 presenting today that has a sick leave ordinance. But it's not use it or lose it. There is a rollover amount. So by ordinance, you should allow employees to roll over or carry over, I'll use those terms intermittently, up to 80 hours of accrued paid sick leave. Are independent contractors considered covered employees? I'll answer on behalf of the city, and it's the same answer for the county. With the exception of domestic workers, independent contractors are not considered covered employees. Can we request the employee to give employers 2 weeks of advance notice for paid leave? Under the city ordinance, there is a maximum of 7 days, and I'll let Jennifer answer on behalf of the county.
Thank you, Miguel. That is the same for the county. So for both the city and county, it's a maximum of 7 days of required advance notice.
For paid leave, can a current employee start using their time accrued right away, or do they need to wait until 90 days after July 1st? So given the July 1st date, I'll answer on behalf of the city. It is the option of the employer as to when they want to allow them to use the paid leave, but it should be no later than that 90th day. As an employer, you have an opportunity and an option to allow your employees to use it before then. And then I will let Jennifer answer for the county, with the caveat that it would be after December 31st of last year, not July 1st.
Yes, and it's similar. It's just that our dates are different for our effective dates for our ordinances. 90 days for an employee who was employed at the time that the ordinance went into effect. So that would be by March 1st of this year. Employees should have the opportunity to start using their paid leave under the Cook County Paid Leave Ordinance. And then any new employees hired, similar to Chicago, would have 90 days after would be able to use that leave 90 days afterwards. And as Miguel noted, an employer can allow for those employees to use that time earlier.
Can an employee elect to use unpaid leave to save their paid leave or paid sick leave?
Sure. So under the ordinance, an employee can decide which leave they would like to use. While the ordinance requires a minimum number of paid leave hours be provided to an employee, if an employer provides both paid leave and paid sick leave, an employee can still choose to use unpaid time.
It's the same for the city. An employee does have an option of which time to use, including unpaid time, if it's available to them. Is an employee who lives and works in New York City, but travels to Chicago periodically throughout the year for work purposes to visit clients in the Chicago office, engage in sales, attend conferences, etc. Are they covered by this law, even though they are already covered by New York City and New York's sick leave laws? So it is going to depend on what you mean by periodically. So with regards to the city, to be a covered employee, someone would have to work 80 hours within that 3 month period. So if that employee never crosses that threshold, then they're not a covered employee and they would not be eligible to obtain or accrue paid leave or paid sick leave. So it depends on what that definition of periodically means. If they're coming to the city once every 3 months and it's only like 1 day, that they wouldn't cross that 80-hour threshold. It would reset. So if they don't come for 6 months, then that's 0 hours that they worked. Can you please explain fractional accruals? It says that it is not permitted. However, if an employee works less than 40 or 35 hours, it would not be a whole number. So how would that work?
So I can answer for the county. While the county, we're requiring that an employee receive 1 hour for every 40 hours worked, but an employer can break down that accrual to be 0.25 hours for every 10 hours worked, or break it down even further. So long as it totals up to 1 hour for every 40 worked.
Sorry, it would be something similar in the city. So you're able to accrue in fractional, but realistically, like you're not going to allow someone to use 2.35 hours of sick leave. Like they're earning it in hours, so like they should have it. They can accrue in fractions, but they're realistically using it in hour increments. So I think that's where the confusion comes in. The next question is, if you are an employer in Illinois, but not Chicago, you would then just follow the Illinois paid leave, correct? Question mark. If you are an employer in Illinois and you are not in Cook County or Chicago, then you would just follow the Illinois paid leave. So if you are a town or municipality in Cook County, obviously excluding Chicago, you would have to follow the county paid leave ordinance.
Yes.
Sorry.
No, go ahead, sorry.
Can you please confirm front loading and carryover for sick leave? If you front load sick leave, are we still required to allow carryover? Yes. So even if you front load sick leave, you have to allow for that carryover. So the exemption or the option of not allowing carryover is only for paid leave and not for paid sick leave. And then Greg, for your second question, I'll also provide Mr. Simon an update. It's similar to the last question, and our answer is yes, but I'll provide something in writing. Can you require notice for paid leave? I will let Jennifer answer on behalf of the county.
Great. So you can, in your written policy, set out a requirement for notice for foreseeable paid leave, but not for unforeseeable paid leave. So someone is planning a vacation or they have an appointment that they want to reach on a particular date. So that's foreseeable. You can require notice. It has to be in your written policy and it could not exceed 7 days prior to the date of the anticipated leave.
Somewhat similar for the city. Yeah, you can require notice, but again, it should be a part of your written leave policy that's provided to an employee. Regarding payout, a large employer is 101 covered employees as defined under the ordinance and not 101 employees nationwide. That is correct. So for the payout provision, we are only counting covered employees. So let's say I am a coffee manufacturer and I have 10,000 global employees and only 25 of them work in the city. I would be considered a small employer because I only have 25 covered employees. So it's not total employees, it would be employees covered under the ordinance. The next question is, when will an update for minimum wage for Chicago be available? So typically, our procurement office decides what the new minimum wage rate will be in the city the first week of June. So be in the lookout, on the lookout for that official update at the end of May, beginning of June. I would like to remind everyone that by ordinance, that increase is capped at 2.5%. So it's based on consumer price index. So at no instance would it increase more than 2.5%. So to give people a general idea, minimum wage is currently $15.80. So you can plan on it not being more than $16.20 next July 1st. Can you clarify payout requirements? The FAQ states payout is only required for up to 56 hours. If an employer provides more than 56 hours, can they limit payout to 56? So yes, and that 56 hours takes into account the possibility of 16 days being carried over. So in that specific scenario, you'd be using an accrual method. Someone did not use 16 hours, rolled them over into the next year, earned an additional 40, and that cap would be 56. So yes, your limit of payout would be to 56. If you're front loading, then you have an option of not allowing a rollover or carryover. In that case, the maximum you would be paying would be 40. So that was sort of the largest possible payout amount. It should never exceed 56 hours, but it had, again, someone would have to be accruing and then rolling over 16 hours in order to even reach that 56-hour mark. If using an unlimited PTO policy to satisfy the ordinance, can an employer state unlimited on the pay stub to meet the pay stub requirement? I'll let Jennifer answer first.
I'm not sure what is meant by the pay stub requirement, but I will note, because the question notes unlimited PTO policy, that is in compliance with the ordinance because it's more than the minimum that is required, at least in terms of the accrual portion, but there's a requirement to also provide notice and have a notice of the employee, like their benefits that they're earning. So if that is what this question is getting at, under the ordinance and rules, I'm not certain that just listing this on the pay stub would meet those requirements. And I'll let Miguel.
I'll answer on behalf of the city. So obviously the city has a requirement where people get notified of available time for them to use. So in this instance, yeah, so if you have an unlimited PTO policy, obviously you're not accruing every pay period, whether it's weekly, bi-weekly, monthly. So we'll clarify through rules and examples, but I do want to point out that you will still need to track how much time people use. So in the city ordinance and the unlimited PTO policy, you may still have to pay out depending on the size of the employer. So let's say I work for you, you have an unlimited PTO policy, and I did not use 40 hours of PTO policy or PTO time in the previous 12 months before I end my employment relationship with you. You may still have to pay out those 40 hours of PTO. So you should still keep track of when people are using the time. So we have to have both paid sick leave and paid leave. So that is a question directed to the city. You have an option of having two separate buckets, or you can have one single bucket, whether you want to call it paid leave or PTO, or as long as people are able to use it as mandated by the ordinance. So you can have paid leave. You don't have to go off into two separate buckets, but then someone should have access to it within 30 days of employment. They should be able to use it for paid sick leave purposes without prior notification, without prior approval. So it's really going to be individually dependent, or like it's each specific example. But there are easily imaginable scenarios where you can have a single bucket of time, and you wouldn't necessarily have to separate it into paid sick leave and paid leave. If we have a PTO policy that includes sick time and paid leave, and it's shown as PTO on the employee's pay stub, is this compliant with the written notification requirement? So it's similar to the previous anonymous question. So yes, if your PTO policy is just paid leave policy and it's showing, and for this purposes of the city, you're providing a minimum of 80 hours or 10 days, and it can be used for purposes as laid out in the ordinance, you would be in compliance with the city.
So for the county, if you have a PTO policy that includes sick time and paid leave, that will be compliant so long as you're providing a minimum of 40 hours of paid leave that can be used for any purpose. So you may have a policy that includes 40 hours of paid leave and 40 hours of sick time, and that will be compliant. I will note that including PTO on the employee's pay stub would not satisfy the written notification requirement, as some of the requirements for written notification include informing an employee of the benefits that they are that are made available to them at the beginning of the, at their accrual period, and a few other things that should be noted, like if you have any requirements for the method they should request leave or things of that nature.
If an employee has an inconsistent schedule, for example, they're not scheduled to work on the same days each week, and they put in a request for time off in advance before the schedule is out, are we required to pay for the day of leave? I.e., should we consider the day they requested off as a day we never would have scheduled them to work, even if we do not know if they would have been scheduled that day?
I'll take a stab at this, or I'll take a try at this one. I think this really depends. I would note that may be to the employee. Maybe they're making a request that they not work that day, and that the schedule can be, cannot include that day, or that if they are set to work 3 days a week, that this count is one of those days and they would like it off. I think it's a little hard to answer in the definitive here. And if that scenario comes up, I think it's helpful to contact either the city or Cook County, so that we can provide some guidance there. I will note that this may be something to include in an employer's written policy, if there are variable schedules that you consider how you would handle that for a paid leave request or sick leave request.
And I'll give a similar answer to what Jennifer provided. It might be okay, but I can also imagine a scenario where it's not okay, where an employer is purposely scheduling someone to avoid them meaningful access to their paid leave. So I was gonna schedule you on Friday, but you asked for it off, so now that's one of your days off. So yeah, reach out for further clarity, or it should be in your written notification of how far in advance it should be. Your employer policy should say like schedules are published every Friday, every Monday, and then people can make informed decisions as to when they're asking for days off. My employees have access to their accrued hours in my payroll system. Is that enough, or do I need to specifically tell them in writing additionally? I'll answer on behalf of the city. So if they have normal access to their payroll system, whether it's through a mobile app or they can go to a website and obtain their current accrued hours, and that satisfies the city's requirements. They have access to it. It gets updated every pay period. It doesn't necessarily have to be in writing. You do have an option of providing it online. So for example, the city uses green slips, and I can log on and check my sick time and vacation time utilizing green slips without having my timekeeper to give me an actual printed out accrual report.
Similarly, for Cook County, I will add that it does not satisfy the requirement laying out your policy regarding paid leave. So kind of those requests for foreseeable leave, the process, that sort of thing. So in the system, there is some also description of pay leave, or you include like your employee handbook or your policies within that system that they can access. That's sufficient. But there are some other things that have to be communicated to your employees that you should also ensure that that's included for their review.
If I have a PTO policy that allows for use of the time for any reason, including sick and just leave that is higher than Chicago, is that sufficient, or will I need to have a separate sick and paid leave in addition, or do I need to replace my current policy? No, if you have a current PTO policy that allows for that time to be used for any reason, and in the city you are providing at least 80 hours of that leave, then you would not need to alter or amend your current policy. Again, as long as other provisions of the ordinance are being followed. So for example, when someone would have access to that time, so you can have a PTO policy that allows for time to be used for any reason, and someone would need to have access to it after 30 days of commencement of employment to keep up with the like sick leave usage parameters that are in the ordinance, for example.
I can note that it's the same for the county, except at least 40 hours. If you provide more than that, that is certainly sufficient.
So to confirm, rules for Illinois paid and sick leave are being finalized in May. I'll speak on behalf of the city. So the city's paid leave and paid sick leave rules will be finalized no later than May 15th. The county's procedural rules are already finalized. And then I do not know the current status of the Illinois paid leave for all act rules and where they stand.
I cannot provide any additional information on that either. I think there's still, the rules are currently proposed, but I'm not sure of the anticipated final date.
If an employee working in Chicago is not covered under the Chicago ordinance, does Cook County apply? Or has Chicago opted out of Cook County such that the statewide requirements under Paid Leave for All Workers Act applies instead? So if you are an employee working in Chicago, you are covered by the Chicago ordinance. The county's ordinance does not apply. So there is no scenario other than like as stated by Jennifer, you're in a union and it's part of a collective bargain agreement that's in place where a Chicago employee would not be covered. For the most part, if you're working in Chicago, you're an employee, not a independent contractor, and you're not under a union contract, then it's going to apply to you. I've already answered the Chicago paid leave. Is there a minimum number of days that can ask for a request for paid leave? I'm trying to keep a current, so we have around 5 minutes left. So I do want to say the questions that were asked by individuals who registered. So if we have contact information for you, we will provide an answer to you via email. For those anonymous attendees who provided questions and we did not get to your questions today, please first visit our either the county's or the city's FAQ document. If your question has not been answered and outreach material that exists already, feel free to reach out to either the county or the city to our provided email addresses, and we'll provide for an answer. So I'll try to rifle through as many as I can. Again, taking into account that there are 5 minutes left in the webinar. Paid leave supposed to be 1 hour per 35 hours work starting on July 1st. In the city, yes. In the county, it's 1 hour for every 40, and it's been that way since December 31st of last year. Can an employer decide a designated vacation time for all staff? For example, business itself goes on vacation or closes for a set time every year. Jennifer, do you want to take a stab at that one?
We have not considered that one. You can provide, I think we noted, both Miguel and I noted blackout periods, so dates where employees cannot take time for operational purposes. I think we have to give, oh, go ahead, Miguel.
Yeah, I was gonna say, you can't force, my initial reaction is that you cannot force an employee to use their time on a specific time. You can say like, these days are not available. But by all means, you have an option to close. We're just closing the last 2 weeks of December, but then that employee would have an ability to use their paid leave at other times. So you cannot designate when an employee uses their time, but nothing's prohibiting you from closing for 4th of July, closing for Thanksgiving. Like that's part of your written employment policy. There's no, like your job site's closed that day, like no one is able to show up to work those days. So if you have a business in the city of Chicago, you should be following the city's policy, not the county's policy. If our company abides by the city of Chicago ordinance, do we need to post the Cook County ordinance poster? If we already post the city of Chicago ordinance poster? No, if you're in the city, you're only required to post the city poster.
And the reverse, if you're in suburban county.
If you're in the county, then you're not required to post the city one. Someone asked, how does each ordinance handle unlimited PTO policies? it is addressed in FAQ documents. If you have additional questions, Mr. Salome, you can reach out to either agency. And the last question that we'll answer this evening officially, and again, feel free to reach out and we'll reach out via email to anyone whose contact info we have. For Cook County, have any municipalities opted out for private employers? And will you be posting a list of opt-out jurisdictions?
For Cook County, I believe we're aware of 1 or 2 municipalities that have opted out. We do not have a full list as it's a manual review. And so there are some jurisdictions that we are not yet aware of that may have taken action.
With that being said, I want to thank everyone for participating and attending today's webinar. The recording will be posted at some point in the afternoon tomorrow. I would share it with Jennifer and she can provide it on her own. Both sets of decks or PowerPoint presentations are available and they can be emailed to you. If you want to make a request, feel free to send either one of us an email. We'll share each other's decks with each other and we can provide a PDF copy of it. And again, I want to reiterate, if there was multiple questions that we did not get to today. So if we have your contact information when you registered, we will get you an answer this week. And if you're an anonymous attendee that asked a question that was not answered, please visit our respective websites to review FAQ documents. And then if you still have a question or it wasn't addressed in the FAQ document, feel free to send us an email. Thank you everyone for your time this evening, and I will give you guys the rest of your evening. Thank you.
Thank you so much. Have a great evening, everyone. And thank you, Miguel.
You're welcome.